Yes.
May it please your Lordship, before the adjournment, I was just concluding on the review point. And just to conclude in this way, that even if this court was to take the view that the review was to be a wider review than we contend for, and that it was to be a thorough examination but looking at the award, we would say nonetheless that the tribunal came to the right conclusion because they didn't rely exclusively on alter ego. It may well be that it could have been better expressed. It may well be that they omitted certain things. But when looking at all the evidence, they came to the right result. And if the test is whether my learned friend's clients have been able to establish that the underlying agreement was invalid, when you have a situation here where what is put is effectively argument rather than new evidence, it's only right that we would be entitled to meet those arguments, and therefore the whole mix would be looked at. And in looking at the whole mix, we would submit that the tribunal's result can be upheld, particularly when one's looking at the application of the facts to French law, which is something that an English court does, in a sense, second-hand, and where you have these competing, what in the end is really theories as to what the facts say, because we don't have any direct evidence, then we would submit underlying all this in the pro-enforcement policy of the international arbitration, that an enforcing court should resolve the doubts, not, as has been done here, always against the objecting party, but in favour of arbitration. My Lord, I move from that now to the issue of discretion, which I've touched on earlier today, but will come back to. The New York Convention, as I said, distinguishes quite clearly between mandatory and discretionary obligation. It puts no limit on the extent of the discretion. And the discretion doesn't distinguish this permissive approach between the different grounds. The discretion applies, although facts of the case will differ, to all of the grounds in Article 5. There's also a discretion in relation to public policy. There's also a discretion in the context of adjournment, and there it's qualified, though I'm not sure it adds a lot, by the words, if it considers proper. And importantly, as I mentioned earlier, particularly where you're looking at a case of this sort, independent of Article 7, because Article 7 is the favoured right provision, but independent of that, there is a discretion to refuse enforcement if an award has been annulled at the seat. And therefore one asks rhetorically, it's said against me, well, what could be more fundamental than a situation where there is no consent? This is on the ex-hypothesi that one gets to the need for discretion. But also one asks rhetorically, well, why did the New York Convention leave in an unbridled discretion in relation to a situation where, even if the French court had set aside this award, the English court, without having the favoured right, could still nonetheless, if it thought it appropriate in those circumstances, enforce the award.
Where do we find the provision about being annulled at the seat? I can't pick that up.
It's where it's set aside. It's Article 5(1)(d)(e) of the New York Convention, or if you want
yes, I see. Set aside.
Yeah. The award has not yet become binding on the
Yes.
parties, or has been set aside or suspended by a competent authority of the company, in which or under the law of which that award was made. While you've got it, Lord Hope, you might just look at 5(2). You see also the discretion in the context where the subject matter is not capable of settlement by arbitration, such as a criminal issue, or the recognition or enforcement of the award would be contrary to the public policy of the enforcing country. And then you get it again in Article 6. If an application for the setting aside or suspension of the award has been made to a competent authority, the authority before which the award is sought is relied upon may, if it considers proper, adjourn. And then you contrast that, for example, with Article 3, which says each contracting state shall recognise. And Article 8, well, I'm not sure that's a good point. So it is certainly there for a purpose. And
It's odd, though, isn't it? It's quite odd, though, if it's a sort of wide general discretion. I mean, for example, take the one about the award not yet becoming binding. Could you really enforce an award which isn't yet binding?
well,
I suppose you could declare its validity, but I don't even wouldn't need to do that, though, would you?
well, it depends in what context it means has not yet become binding. It may be that it had been declared, but perhaps, I mean, I'm thinking aloud, but hadn't been scrutinised by the ICC or something like that. There may be a provision where it's contingently binding, but hasn't yet become binding. I don't know is the answer.
And does the convention really contemplate that it can be enforced throughout the 144 states, even if it's been set aside by the court of the seat of the arbitration?
Well, that's what it says.
Well,
My Lord, I'm not saying this should be exercised arbitrarily, but I'm seeking to persuade you that it should be wider than what was said by Lord Mance in UKSC and Dallah, because in that case, with the greatest respect, your Lordship perhaps was looking at the discretion, but in a slightly different context, because there was a background of adjournment.
could we just, speaking myself, I'd just like to look and see how it was put.
Yes, of course. It is actually, I have actually for ease, but
In your case,
it's
yeah,
entirely up to you. I have
case
set
we
it all out in the case,
Yeah.
simply for easier reference. I've set out all the English cases, in fact.
Yeah, the case would be fine, I wasn't.
And it's at paragraph. Sorry, I was working through different notes.
183.
183, I'm grateful.
Yes.
There are 4 cases where it's been dealt with in England, or discretion has been touched upon. And I hope I quoted the relevant parts of Lord Mance's judgment. And then it was brought up again in IPCO in the context of an adjournment, where Mr. Justice Gross, as he then was, says that, but such matters, it's probably towards the end unwise to generalise. All must depend on the circumstances of the individual case. Now, I know that's in the context of an adjournment, but we would say that applies equally in the context of enforcement. And then Canoria, which was the case where it was clearly unjust to enforce, Lord Phillips says at the bottom of the quote at paragraph 185, even if there's a wider discretion, I would not exercise on the facts of this case. This is an extreme case of potential injustice. And what I'm doing is I'm submitting to your lordships that the test really should be the justice of the case.
It's quite interesting, though, isn't it? When you're talking about recognition,
Yes.
what is to be recognised or what is not to be recognised, the convention is quite firm. It says you shall do that.
Exactly.
And when it deals with procedural matters, Article 4, for example, you shall supply, you shall do this and that. But every time you come up against enforcement or recognition, the word may is used. And that probably could be said as, and perhaps I'm echoing Lord Mance's point, that there are various defences that might come in. Estoppel is probably the prime example, where the court would feel it not proper to do what it's allowed to do.
Yeah.
So it's giving a power to the court, and it's probably recognising that courts prefer to exercise a power rather than be told what to do, directed what to do by convention.
But with respect, there are a couple of answers to that. Your Lordship used the phrase, if it's proper. Interestingly enough, in the adjournment context, it uses that phrase. It doesn't use it in Article 5.
No.
But secondly, obviously, the examples given by Lord Mance would be examples. All I'm suggesting is it is not as narrow as that, because a discretion inevitably gives to the court exercising that discretion the right to do what it feels to be just in the circumstances. Now, as I say, estoppel would be the most obvious. But if, as is said against me, it is so unlikely that you would have a discretion where there is no consent, one might have expected it to be in a different part of the article. But all the grounds are dealt with in the same way. There's no distinction. They're all prefaced by the word may. And
I suppose it doesn't mean that the extent of the discretion is the same in relation to each. I mean, I think you made a point, which I see has force in relation to E, that you could have a situation where an award is set aside, and let us suppose it's set aside in very suspect circumstances, maybe even set aside without proper notice. But whether or not that, there's some suspicion that the local courts may be subject to government influence and it's set aside, you might then find in England that it was more difficult to persuade the court to refuse to enforce. The basic thrust of Article 5.1, though, look, it has been suggested, is the other way round. It's really designed to emphasise that these are the only grounds on which you can refuse, rather than to emphasise that you can nonetheless enforce even if these grounds exist.
Well, my Lord, I mean, I entirely accept that to this extent, that it will depend in each case on the facts of each case, not necessarily only the ground. But although different grounds will be looked at differently in the context of the circumstances, the fact remains that the Convention doesn't distinguish between it. The Convention simply says, emphasising the pro-enforcement policy, recognition may be refused. So there's a presumption in favour of recognition and enforcement. It's not a presumption against it. It doesn't say you may be entitled to recognition. It says recognition and enforcement may be refused. And that's an unusual way of putting it. Normally one would expect, certainly in English statutes, recognition and enforcement may be granted, but that's not what it says. And that, we say, is consistent with the presumption that there should be recognition and enforcement unless one of the parties, A, can get itself through one of the gateways, and B, can persuade the court that it's an appropriate case, and we would say, in the justice of the case.
But if you get through this, if they get through this gateway,
yes,
so that the enforcing court has held that the loser, as it were, the original loser, was not a party to the agreement, on what basis could a court properly make an order enforcing the award against somebody it has just held isn't a party to the agreement?
Well, there may be a variety of circumstances. One would be estoppel, another might be contradictory conduct, another might be bad faith. And to give you...
How would it be bad faith? I'm so sorry.
I'm not saying I'm alleging it, but I'm just saying the reason I raise that is because I was just going to take you to one authority to which I refer, and maybe we can probably deal with it from the extract, which is the case of Hebe, which is a case where Sir Anthony Mason
186
gave the leading judgment. If you would like to look at it in the bundle of authorities, as it's the only authority I'm probably going to refer to, it's volume 2, page 61. It might just be easier. This was a case about, on the grounds of public policy, where there was an issue. It wasn't really a public policy issue because the issue was whether or not the tribunal had acted properly in relation to seeing some experts, and it was dressed up as a public policy issue. But it's the general comments that are made, and I think if one starts... I mean, a passage that I quoted earlier in my submission is at the bottom of page 35. the Convention, in providing that enforcement of an award may be resisted on certain specified grounds, recognises that though an award may be valid by the place where it is made, and this is the context of public policy.
So sorry, which page are you on?
I'm just reading, just to put it in context.
The page you're looking for the quotation is
bottom
page
of
39.
page 35, the last word of the Convention starts top of page 36. And this is the context of public policy. Although an award may be valid by the law of the place where it's made, its making may be attended by such a grave departure from basic concepts of justice as applied by the Court of Enforcement that the award should not be enforced. And then the relevant passage is really
61, yeah.
at page 39. The approach was adopted. This was by Catherine J. in China Nahai oil case concerning the constitution of the CTAC tribunal. His Lordship held that the ordinance and the Convention conferred a residual discretion on the Court of Enforcement to decline to refuse enforcement, even if a ground for a refusal might otherwise be made out. I agree with His Lordship that the use of the word may in Section 44 and Article 5 of the Convention enables the enforcing court to enforce an award, notwithstanding that a Section 44 ground might otherwise be established. Whether a court would so act in such a case would depend in very large measure on the particular circumstances. And that's the sentence I rely upon. So that's a general statement. He then goes on to deal with the particular situation in that case. It is difficult, I think that should be it rather than if, it is difficult to imagine that a court would do so if enforcement were contrary to public policy. But there is no reason why a court could not do so, whereas here the factual foundation for the public policy arises from an alleged non-compliance with the rules governing the arbitration to which the party complaining failed to make a prompt objection, keeping the point up its sleeve, at least where the irregularity might be cured. Whether one describes the respondent's conduct, and this is why I bring in conduct, as giving rise to an estoppel, a breach of a bona fide principle, or simply as a breach of principle, that as a matter of non-compliance with the governing rules should be raised promptly in the arbitration is beside the point in this case. On any one of these bases, the respondent's conduct in failing to raise in the arbitration its objection arising from the communications to the chief arbitrator was such as to justify the Court of Enforcement in enforcing the award. And then he says he doesn't need to deal with the other point. And there are some other points which I've referred to in the case also from this case, like the unification of standards. So
if it was simply a breach of procedural rules which wasn't drawn to the attention of the arbitration, I can't see how actually you could get anywhere near the public policy exception at all.
Well, I agree, but the point I was making was not from the facts of that case, but the two statements. One, that you look at the particular circumstances of the case, and two, that you can consider comment.
Yes. I mean, the point I was making is that they seem to me, on the face of it, to have been considering it at a stage later than it actually arose. You could simply have said there's no question of public policy if there was a point of procedure.
Well, I think they said that as well. Yes. But I think they were dealing with that as a secondary point.
But I still have some difficulty in seeing how you could have a situation where a court could properly enforce an award against a person whom it had just held wasn't a party to the agreement that gave the arbitrators, which was the sole instrument which gave the arbitrators the authority to do what they had done. I just can't think myself. I mean, the reasons you give in your skeleton are really going back to the points we were on before, that one should have regard to what arbitrators do and so on. And I can see that may or may not come in at an earlier stage. But
well, it can. I mean, it may come in at two stages, but it can, in our submission, come in at this stage, because if there's contradictory conduct, it perhaps will...
I mean, I can see you can say that the government are a shower and they had absolutely no business pulling the rug from under your client's feet, and the whole underlying idea of the MOU to which they were a party, by failing to resurrect the trust. I quite see that. You could say that's disgraceful conduct, that's malafide. There might be all kinds of causes of action you might have. But here, we're only looking at the question of whether they were a party to this agreement, and the moment at which we'd be exercising the discretion would be after the court had held that they were not parties to the agreement.
Well, I accept that.
That's
but
what's troubling me, at least.
Well, at the same time, that discretion is there. And it is obviously, will depend upon, as I said, or I submitted, the facts of each case, so that you could have contradictory or dilatory behaviour, for example. You could have, as I'm not alleging it as such, but you could have bad specific, really bad faith, if you know what I mean. Or you could have waiver, you could have estoppel. But the golden thread, we say, is what is the justice here of the case when looking at it in the round, remembering that we are looking here at international arbitration, the pro-enforcement policy of the New York Convention. And we would submit that the golden thread is the justice of the case.
It's a sort of lifting
But
of the
the
veil.
golden thread, surely, is an agreement by the parties to submit a matter to an arbitral tribunal.
Yes.
And if you haven't got that agreement, I rather share Lord Clark's view, as he's expressed it a moment ago, that it's very difficult to see how, once a court asked to enforce the award has decided that there was no agreement between the parties to refer a matter or any matter to arbitration, nevertheless, despite the absence of such an agreement, somehow the party in question is bound by what the arbitrators have said.
Well, may I make two comments? Obviously, the first comment that I made is what there is unlimited discretion. It's not defined in the New York Convention. The second is you might have a case where, in a sense, this case could fall into, where it is a borderline case, where it is not clear whether or not they consented, where it is impossible on the evidence, for a judge really to come to a clear
But in that
view.
case, they wouldn't satisfy the burden of proof.
Well, yes and no. I mean, I see that in the first instance, you would have to, on the balance of probabilities, but it may nonetheless be very much a borderline case, in which case the tribunal might look at it differently.
But with respect, as my Lord Clark has just said, we're assuming a position where, in this case, the government of Pakistan has proved that it was not a party to the agreement. In this jurisdiction, the standard of proof is the balance of probabilities. Okay, on the balance of probabilities, there was no agreement between the parties. And I'm finding great difficulty in seeing, nevertheless, leaving aside questions like estoppel or waiver or anything else like that, nevertheless, the court could ever say, well, all right, you weren't party to it, there's no waiver, there's no estoppel, but we're going to hold you to it. I just don't see how it could possibly follow.
Well, all I can put to you is that in that situation, the court would be looking at the overall justice of the case, and therefore, even in those circumstances, whether it was right by virtue of the contradictory behaviour, nonetheless, I understand, of course, Lord Savile's point, but whether nonetheless the Convention gives the court a right in such circumstances, because of the way that the party has behaved, to say that in the circumstances of this case, the award should be enforced. My Lord.
Well, I follow that submission. If you're relying on specific legal principles like a later estoppel and so on, but I'm finding difficulty with a concept like the justice of the case, where none of those things arise, and the only thing that's been established is that there was never an agreement between the parties.
Well, my Lord, those are my submissions. I mean, it is a short point, because it's the question of what may mean in the context of the New York Convention. And our submission is it is not circumscribed. And we still reiterate, and if I can just give you briefly.
I mean, it sounds like the absolute classic palm tree. I mean, it sounds as if you're inviting the courts to say, well, they very nearly agreed, or it looks as, they nearly won. As my lord says, we apply the balance of probabilities, but on your test, they had a 40% chance of success. They've lost. Why on the palm tree principle? Why not award them 40% of the award? That's not how courts work. We arrive at a decision, and that's the answer in general.
But then you do have arguments such as waiver or estoppel, which would meet the case, and there may be situations which are one below that in the circumstances of this case, which would nonetheless entitle the court to say that this case should be enforced. Can I just very briefly canter through my 10 reasons as to why we say you should enforce it, and just to make good that point?
Are these set out in the case?
Most of them are. There are perhaps a couple more I could add.
Right.
Rather than detain your lordships. My lord, the first point I just want to mention is the position in France. Your lordship will have seen that we put as a separate ground, although I rely on it in the context of discretion, estoppel. That was on the basis of a statement that the government was not going to go to France.
Yes.
Since then, and since our application, or before the application, because of the Court of Appeal decision, although we are no longer obliged to do so, and as you've heard, the whole purpose of the New York Convention was to avoid this, we have lodged proceedings for enforcement in France. Since then, the government have put in a detailed opposition to that, and therefore, to an extent, that takes away the finality argument for the purpose of arguing before this court that there has been an estoppel. And therefore, I wasn't proposing to argue estoppel as a separate issue, right, but I nonetheless wish to retain it in the context of the discretion, because we foresaw it would be difficult for this court to say that there was an estoppel when the French courts are actually about to determine the issue, and therefore the finality argument as at today's date would be difficult for you. Nonetheless, it is relevant in the contents of the discretion.
So I haven't quite understood this. The government said that they weren't going to go to France what to do. They weren't going to set aside the award.
They weren't going to set aside the award. But what happens in France is if you seek to enforce, you have a month in which to oppose it. And therefore, when my clients sought recently to enforce, the government then effectively were, unless they were going to let it ride, have put in an application to resist that enforcement.
And also to set aside the award, or not?
And to set aside the award.
And to set aside the award.
Yes. Mm-hmm. It's a part and parcel of the same.
Yeah.
But they didn't do it on their own initiative. They did it because we went there to enforce.
Yes.
And the point, it seemed to us that it would be very difficult for your lordships to argue as a separate issue,
yeah,
for us to say it was final now, when the matter is going to be determined by the French courts. That's a different issue as to the question of estoppel in the context of discretion, because that is a separate issue. So we were not going to pursue that separate issue before your lordships in the light of what's happened since the appeal, because we couldn't see how your lordships could say it was final if the matter is currently before the French courts.
And is there an issue in those proceedings whether or not whoever loses in these proceedings is stopped from arguing the point in France? Or are you waiting to see who wins before deciding who's going to be on which side of that argument?
Sure.
It's presumably not. I mean, any judgment we give is outside the Brussels regulation.
It is indeed, yes.
But if you applied the SENA, English proceeding principles of issue estoppel, it would be binding, but that depends whether the French have that.
Well, indeed. But one of the arguments before the court below was that because they hadn't said they were not going to France, therefore, from the perspective of conduct and their own attitude, they had effectively were stopped from saying that the award was not binding.
Andrew, if we're testing that today, I mean, your side's only got themselves to blame, really, now they've gone to France.
Well, that's why we're not pursuing that.
Well, how is it relevant to discretion either?
Well, it is relevant to discretion because there's a distinction between, this is part of the, there's a distinction between them positively saying, as they did, they are not going to contest it, as at the time of the issue of enforcement. And us now, because of what's happened in the English court, being compelled to do something which the New York Convention specifically endeavoured to avoid us having to do, namely to go to the court of the seat, effectively for a double execution.
Yes, but you're not going to the court of the seat, are you? You're going to
France
Quay, but that's only Quay Enforcement Court.
But that's the only way you can do it. That's the only way we can do it. The only way we can get the issue before the French courts, by seeking to enforce it.
What did they say, as a matter of interest? Where was it in relation to the French proceedings? Where is it in your case?
It's set out, I think, in the agreed statement of
yes.
facts, which is, sorry.
Oh, yes, I see, paragraph 73, yes.
Yeah. So,
But all they said is that they weren't going to challenge, they weren't take positive steps to challenge the award in the French courts.
they said they've been, yes.
Yeah, well, they weren't obliged to.
Indeed.
No, so it's a non-point, isn't it? It would always have been a non-point.
Well, it wouldn't with respect, because if one at that stage was looking, irrespective of what happened subsequently, as to whether or not the award in France was final. The problem with France is many jurisdictions have a time limit, as we do.
Yes, correct.
28
well, they had a
days.
month from the time when you sought to enforce.
But with respect, there's a difference. There is no time limit unless we seek to enforce. So under French law, in theory, you can apply to set aside at any time.
Yes.
And that's the difference. There's no time limit.
But why should they? I mean, if they didn't have any assets there, it's the old story. If somebody commences an arbitration in a jurisdiction or proceedings in a jurisdiction with which you say you've got nothing to do and you never agreed and never submitted, you're entitled to just say you do what you can there and see whether you can enforce.
Well, it's the Svenska point, where in the Svenska case, it was held that as they hadn't been, the fact that the law is slightly different, it was Danish law, but the expert evidence in that case was that, although there wasn't a time limit in Denmark, nonetheless it was reasonable to assume that the award was final. It just went to the finality point. But to a certain extent, as I said, it cannot... we have initiated those proceedings in France because... But contrary to what was the underlying intention of the convention to have to do so. So the point being, the only reason I raise it in the context of discretion is, although, as your Lordship quite rightly says, there was no obligation to do so on the part of the government, as at that point of time, subject to the fact that we have subsequently gone to enforce, there was a finality we would submit, or an indication that after all 7 or 8 years have lapsed, that there must come a point where that award would be final. And that, therefore, them having decided not to set it aside, and they were entitled to, but it is a further ground in our submission simply to look at the overall conduct in relation to the government.
So can I be quite clear that the point rests then on the last sentence of what you quote in paragraph 73
yes,
in the
there is in
Statement of
fact,
Facts
if one
and
looks
Issues?
at the letter, which is in bundle D, I have a feeling
That's the one we looked at
may have
earlier.
missed out one sentence of the next sentence.
Right. It's the letter we looked at earlier, isn't it?
Last paragraph.
It's in
It's
bundle-
paragraph 73.
in the yes.
Yes.
Can you just find it? The letter.
Well, the advice by the French lawyers may well have been, you'd be mad to come to France when you haven't got any assets here, and there's no need to do it.
Yes.
Or it might have been, I wouldn't come here if I were you. The French court will undoubtedly uphold the award.
I don't know what it is.
It's now going to be tested.
Well, we'll find
Probably
it.
that advice that prompted your clients to give it a go in France, I don't know.
I think the only other points that I...
But I think the idea is jolly rotten that your clients have had to go to France. And what your clients did, they went in England, and they've only gone to France, now they've lost in England.
Well, but my lord, one of the problems, of course, which pervades this case is that there is a difference, however much an English court is used to it and does, apply a foreign law to facts, from the court itself applying its own law to the facts. However much an English court is imbued by the experts as to what the law is.
I don't follow that, but your clients could have gone to France on that basis, got the thing, an order for the enforcement in France, and then you'd have had a jolly good issue estoppel here.
But when asked rhetorically, why should, because this is not what the Convention said, the Convention specifically, unlike the Geneva Convention, says you do not need to go to the seat to get enforcement. That's the whole point of the New York Convention, was to avoid having to do that. And it was only because of what happened here that course was taken. But that shouldn't be an obligation on our part. We should be entitled to seek to enforce in any of the 144 countries in the world that we want to. We don't have to go under the New York Convention to the seat first.
No, but there's nothing in the Convention that suggests that if you lose in enforcement country A, that you should be free to go round to the other 143 countries to have the very same point relitigated. There's no suggestion to that effect in the...
Well, you can, with respect, subject to
subject to issue estoppel.
Those courts having an issue estoppel. There is nothing to... As I've said, would have been nothing to stop us to go simultaneously, for example, to 4 different courts.
Well, you might want to do that where there are not sufficient assets in individual countries,
Indeed.
quite apart from issue estoppel. You
Indeed.
might just wish to go around the world enforcing your award.
So I think the only a couple... I won't repeat the points that I made about discretion, but just 1 or 2 new points that perhaps have arisen during the course of the debate.
Yes. Sorry to go back to these reasons. I'm looking at page 91 of your written case, where you really draw together your propositions that are in the case. Is that what we should be looking at now, or is there something else in the written case we should have in front of us?
That sets out the French position.
Page 91.
Yes. There's no time limit on the government themselves applying to set aside. They had no obligation to do so, I accept that. But if we bring enforcement proceedings, then either they let it go, because it's a similar procedure to us, without notice and then a full hearing, or they have 1 month within which to say they are opposing enforcement, which is what they've done. So the only way that they effectively could be brought to a head in France is if we bring enforcement proceedings. That's how it works. Just finally, if I may, on discretion, just to deal with some new points rather than repeat the ones that have already been set out. There was some talk about vague alternative remedies. We're looking into this, but my recollection is that there was some... It wasn't an unopposed view, and the remedies were remedies which were not easily available to my clients. Overnight, we're going to see if we can get an agreed position on that, so that your lordships are aware of the position. The other thing is that, as I mentioned during my earlier submissions, this was a situation where my clients, it said against me, well, my clients took a commercial risk. But my clients had been lending to the government for a number of years, had been providing Islamic finance, and had had no problems as far as I'm aware. The money had been repaid. One would assume that they were entitled, therefore, to rely upon a state, sovereign state, particularly given their past experience. And what they found here was that, effectively, the contract was taken from under them, and they were left without any recourse, and we would submit, in breach of what are international commercial obligations. And so it was that injustice which underscored the tribunal's decision, and we would submit should also be relevant in the exercise of the discretion, because here you have a government involvement in the MOU, a government involvement in the formation of the trust, a government involvement in keeping the trust alive for 2 promulgations, a government involvement in deciding to allow it to elapse, a government involvement in the letter, and a government involvement in 2 court proceedings. And so they're now seeking, if they're right, to walk away from that on the basis that there isn't an agreement. And looking, as we said, at the overall justice, my Lord, we would submit that the right approach, even if you were wrong, against us on the argument as to whether or not they were a party, should be nonetheless, in the special circumstances of this case, to enforce the award. My Lord, finally, because I know my friend will make a point of this, of course the government of Pakistan is a state, and of course it has sovereign rights. But as the evidence indicated, and as in fact Mr. Justice Aikins himself said, it's only one of the factors. And in our submission, it should not be an overriding factor when looking at everything in every aspect of this case, because the government here were involved in a commercial deal, and there is nothing, we would say, which should take it out of the ordinary realms of either the ordinary test of common intention or the ordinary nature of the review, or ultimately the question of discretion. And we would submit that in all the circumstances, this court should resolve the doubts in favour of the arbitration, consistent with this court's previous decisions in Lesotho Highlands and Fiona Trust, where this court has given a strong message as to the importance of international arbitration, the importance in the international community, the English court's attitude to enforcing arbitral awards.
By resolving the doubts, you're talking about the doubts on the issue of fact, are you?
Doubts on the issue of fact. That it's not. You have here a situation where, as I've said a few times, it's not somewhere where there's a lot of new facts are brought. It's an interpretation, interpreting a person's mind for objective behaviour. And the essential difference between the tribunal and the court was reading into an individual's mind who has not come to give evidence, on whom the onus of proof rests, as to what he thought when he was writing that letter. Do you look exclusively in isolation at some proceedings that same day? Do you infer without any evidence that it was simply a mistake?
What I haven't quite understood about the French law is if it's a subjective, if you're looking at the subjective intention of the parties, and that is the law that subjective attention has to be obtained entirely from the objective indicia? I mean, suppose somebody goes into the witness box and says what my subjective intentions were, but there were no external indicia. Would the would-be intention be established as a matter of French law?
My Lord, rather than me trying to be a French lawyer, there was this
Well, what's the
similar
answer? Yes,
point.
what's the answer, yes or no?
Well, I was going to actually, because it's not quite so straightforward, I was going to actually take you to when Mr. Justice Aikins tried to elicit a similar question from the witness, and it might just be easier if I can find that passage from the evidence. Can you just give me my... Give me 1 moment. I nearly gave it to you yesterday, and then shortened it. Speak, yes.
Yeah.
It's I'm grateful to my friend. It's page 89, bundle B, flag 5.
This is Justice Aikins' judgment, is it?
No, it's bundle B. It's the transcript.
It's French.
Where
Okay,
where Mr. Justice Aikins was trying to fathom out.
But that's where the answer is it's a very difficult question.
It's a very difficult question.
Is that what he says?
That's why I was going to try.
It's a very difficult answer.
Take refuge in the transcript.
Which page?
Page 89.
Right.
At 7, Mr. Justice Aikins, Monsieur Vattier, in English law there's a distinction between an objective intention of parties to a contract, that is to say, the intention of such party as manifested to the other party by what is said, what is written, or what is done. On the other hand, there is the subjective intention of a party, which is the intention that each party has in its own mind or in internal documents, or what is said within each party's boundaries, but is not indicated to the other party. What I was interested in yesterday and would like your opinion on in French law is whether, when a judge is looking for the common intention of the parties, for the purpose of seeing whether they are party to an arbitration agreement, his investigation is limited to the objective intentions as I have described them, or whether it also includes subjective intentions as I have described them. It is a difficult question because we don't recognise such a distinction in French law. On the other hand, the French judge seeks the subjective intention, but he may deduce the subjective intention from objective behaviour. In arbitration cases, the case law shows that the intention of a party subjected to arbitration may lead it to the liability of a party that was not a signatory to the arbitration. But in this case, the intention of the party, and then Mr. Angeli corrects it, the word is involvement. The involvement of a party that was not a signatory to the contract must be manifest and positive. So what that means is that the case law seeks through the objective conduct of the party its subjective intention. The assessment is indeed towards subjective intention, as can be seen in the case of the so-called pyramid case, where although the Egyptian government was involved in the arbitration, the Court of Appeal judged that it had been its intention to submit to arbitration. Do you mean involved in the arbitration? Sorry.
Doesn't the answer at line 11 and 12 give the answer to Lord Hope's question? The involvement of the party who was not a signatory to the contract must be manifest and positive.
Well,
so what that means is the case law seeks through the objective conduct of the party its subjective intention. So it must, I think Lord Clark's question is answered, isn't it?
Yes, it is really.
You are looking well, I think...
So you can't just have the subjective intention which you're thinking in your bath.
No, you've got to look at the objective intention.
Manifest.
Manifest.
Yes.
Across the line.
It's very, I mean, it boils down actually in the result probably to a pretty similar result to the one we would arrive at.
Or put another way, it's got nothing to do with subjective intention.
No, but philosophically, subjective intention is more attractive in some ways.
But, I mean, the summary that we both adopt the summary that I think I'm right in saying that Mr. Justice Aikins adopts in his... I've only given you a part of the evidence, and of course you've seen the memorandum. That deals with the subjective aspect. Monsieur Valtier, I think I read to you yesterday, saying that you look at the objective behaviour. The extent must obviously depend on the circumstances of the case. But in our submission, the objective behaviour here did manifest an intention. And I don't want to repeat what I've said. So, my Lord, I think that really, unless your Lordships have got any further questions of me at this stage...
Thank you very much, Miss. You've been extremely helpful. Mr. Reichert? No. Well, their Lordships would like to confer for a moment or two. If parties would be kind enough to remain in court, we'll retire for a moment or two. Mr. Landau, we don't need a reply on the estoppel point, which has effectively been dropped by counsel. We don't need a reply on discretion, but what we would welcome your assistance on is the nature of the exercise which is mandated by Article 5 and brought through in Section 103. Secondly, your advice and comments on the issue of transnational law and its relevance, and thirdly, the relevance, if any, of the principle of competence. These 3 points would be of assistance to us.
I'm grateful, my Lord.
Thank you.
May it please your Lordships, can I begin with a reservation with respect to state immunity, which I just put on record, as I have done on every occasion previously, which may be important insofar as this case comes up elsewhere. The respondent, as your Lordships is aware, is a governmental entity. It claims state immunity. The government of Pakistan has maintained that reservation throughout these proceedings. It has pleaded state immunity as a separate head in response to the original order of Mr. Justice Christopher Clark. That point is not argued separately, simply because in the light of Svenska and Lithuania, it is coterminous with the question under Section 9 of the State Immunity Act, whether or not the government of Pakistan is bound by an arbitration agreement. Having said that, for the avoidance of doubt, the government maintains that there has been no waiver and that it holds its reservation, and nothing in its participation in these proceedings must be taken as a waiver of any sort.
Yes.
My Lords, can I introduce the 3 issues that your Lordships have outlined for me with a general overview, which I promise won't take long. This case, if one steps back from the heat of the argument, has been portrayed, in particular by my learned friend, as a case where the English court has come to an anti-arbitration position. The New York Convention is said to be pro-enforcement. This is said to be a rare and surprising instance of the non-recognition, non-enforcement of an award, with few previous examples, and a potential blot on England's reputation as an international centre for international arbitration. That, in my submission, is a completely wrong characterisation of what has taken place in this case. It's quite an important characterisation to debunk because of the ripples through the international arbitral community after this case, in the light of this case. And it's important that it's made clear in my submission what actually happened in this case, which has not been perhaps universally understood, or perhaps understood in sufficient detail. In this case, what happened simply before Mr. Justice Aikins and before the Court of Appeal was the proper application of the New York Convention as it was originally intended. No different from what would happen before the courts of France, see SPP and the Pyramids case, which we will come to later. No different from the courts of the United States, from the courts of Switzerland, the courts of any of the recognized international arbitral centers. The essence of this case, my lords, is that the government of Pakistan maintains it never agreed to arbitration at all. The issue is initial consent. That is the key characterizing feature of the case. It is not a case about the scope of a tribunal's jurisdiction. It is not a case about the nature of their determination. It is a question, the logically prior question, was there an arbitral tribunal at all? My learned friend's arguments in different formulations come to what sort of deference should this court give to an award? Should there be a presumption? There are cases in Canada, the United States, that have been put before this court where presumptions are applied. Should there be some special weight attached? None of those cases involve initial consent.
So if we were further down the line, and obviously if we were faced with an issue about substance, it would take on a completely different aspect, would it?
Yes.
So your point is we're right back at stage one, at the very foundation of the agreement itself.
My lord, yes. And when I get to it, I will show your lordships that there is a principled analysis of Article 5 of the New York Convention. Article 5 comprises a number of different types of grounds. You can do a very simple exercise through Article 5 of going through each one and asking the question, does it assume that there is an arbitration agreement and a valid tribunal, or does it raise the initial question? So, my Lord, if I'm, with your permission, take my course, I will come to that shortly. And for those grounds in Article 5, where there is no assumption that there actually is an agreement at all, or a valid arbitral tribunal, then there's no basis for a court as a matter of logic, as well as the intentions of the New York Convention. There's no basis to treat the alleged arbitral award with any particular deference.
These grounds are severable as a matter of language as you work through the article, but they're all covered by the word may.
They are.
But at some point you have to explain why that's so.
Yes, indeed. Each of them is covered by may. We don't, of course, that's absolutely right. But as my Lord Mance, I think, raised earlier the point, there's nothing in either the history, the language, the scheme of the New York Convention to suggest that it is the same discretion test that is applied to each of these grounds, because some are very different analytically. For example, Article 5.1a raises the question of initial consent. At that point, as we are in this case, there is only an alleged arbitral tribunal. Article 5.2a, in contrast, is a question of public policy. That assumes that there is an agreement to arbitration. It assumes that there is a valid, legitimate arbitral tribunal with status. At that point, as Mr. Justice Coleman and then the Court of Appeal in the Westacre case did, the court would, of course, pay some deference to that arbitral tribunal's consideration of the issue of public policy. Not that it's bound by it, but of course that would carry some weight, because at that point you are dealing with an arbitral tribunal that is an arbitral tribunal. It has a right to form a view on the issues. Whether or not that's persuasive for the English court will depend upon how good that determination is. But that shows that Article 5.2a is not the same as 5.1a. 5.1a raises the logically prior question, is there an agreement or an arbitral tribunal at all? Now, my Lord, I'm at the stage which is dangerous for an advocate of the executive summary, because one gets drawn into the meat of the argument before having arrived at it.
Well, the interesting thing, of course, about Article 5 is that it doesn't actually draw the distinction you're mentioning, but I suppose you can get it from Article 2.
Lord,
in UKSC and Dallah, the argument was that Article 2, in its domestic reflection, meant that the person seeking to enforce had to prove a valid agreement in writing, and one can see the argument, because there it is, the contracting states only have to recognise an agreement in writing under which people have undertaken to submit. But we came to the conclusion that if you looked at the mechanical procedure in 4 and 5, actually it shifted the onus.
yes.
But I think you can get the importance of there being an agreement. The fundamental agreement is to recognise what has been agreed in writing. Whether
The analysis that I have set out is not in terms in the New York Convention. No. I'm reading into the word may.
Yes.
But to make sense of the convention. The analysis, if I may, with respect, say, in Dallah and UKSC was absolutely right in terms of the stages. And all of this gets shifted into Article 5. You can't resolve it before Article 5 without disturbing the burden of proof.
Yeah.
So that must be right. But then if you are left with may in Article 5, one has to make sense of it. And that, of course, as with any international convention, has to be made sense with respect to purpose and object and whatever customary international law features perhaps in the Vienna Convention. But my Lord, I will come to that, if I may, in order to keep the logic of the argument in a little bit more detail when I analyse each of these provisions. When one gets to the cases that my learned friend has cited, which use presumptions and deference, each one is clearly classifiable as either a question of initial consent or a subsequent question of scope or some other issue where you already have got beyond that first threshold. And if I just, in abstract, just mention the classic example of this comes from the United States. The two cases that have been cited before this court from the United States, which were not cited previously, are China Minmetals and Parsons not the public policy Parsons, another Parsons and Whitmore case. Again, that was all set out in my overly long written case.
Paragraph?
Just give you that. Lord, it's paragraph, it's page 85 of my written case, paragraph 256, I'm embarrassed to say. And it's with the heading, subheading United States. And I've there cited Parsons and Whitmore overseas and Chinamin Metals. Those are two cases cited by my learned friend for this appeal. Now, I just picked those out at the moment by way of my summary, because that is a classic and very clear example of this difference of stage. In Parsons and Whitmore, you have got the application of a presumption onto an award. They talk about a powerful presumption. And when you get to Chinamin Metals, it is a de novo review without any presumption. The difference is Chinamin Metals is a case of initial consent, and Parsons is a case of scope. Now, I'm just picking that out as an example of...
So can I just see what the judgment says? It says a party who makes that kind of allegation, it said, is entitled to present evidence to the district court, which must make an independent determination of the agreement. Does that bears on the nature of the exercise, then, does it?
Absolutely.
Independent.
So what the independent determination of the agreement is exactly what this court must do.
You assume the arbitration panel has set aside itself that it has jurisdiction, and therefore it has actually addressed this issue and reached a view. But nevertheless, when the district court looks at it, it's an independent court, its own view, de novo.
De novo. And that, in my submission, is the same standard as for this court. You may well find an alleged tribunal's award helpful because it's well reasoned. But you have to, as a court, a recognising and enforcing court, you have to arrive at your own determination.
But only in the same way that one might or might not help. I think counsel's argument was helpful.
Precisely.
On the basis that it is or isn't well reasoned.
There are levels of coherence in submissions and in awards. There are times where an award is extremely helpful and makes the court's job easier. But that doesn't change the nature.
You say that's got nothing whatever to do with deference or who the arbitrators are or anything. It's just like argument, really.
Absolutely. And I've encapsulated my submission is a very simple point. That's why you've got such a lengthy written case from me. I've encapsulated it in paragraph 233 in bold, which is what my learned friend took issue with. But what
it's a shame to have to get to paragraph 233.
Well, I put it in bold because I thought people may be weary by this stage, but...
So at least we picked this bit up, is it?
233 in bold is really, in my submission, all that one needs to say on the level of review, which is you've got to form your own view. That's what the New York Convention requires of you. It's what the 1996 Act requires of you. You may be helped by the award of the alleged tribunal, but you are neither bound nor constrained by it. You might go further than the award. You might look at things that the tribunal did not look at. That's not a very technical test, but it's a clear one. And in my submissions, I will show your lordships that is exactly what was intended by the New York Convention. Lords, I'm going to, again, apologise because the executive summary is going to envelop my main submission. But I'll come back to my summary and then I'll run through these points bit by bit. At the core of this is, of course, the doctrine of competence. Now, one needs clarity. Again, this is at the level of summary at the moment. One needs clarity on this doctrine because it is a misnomer to call it competence, although it has been called that for some time.
And are you using it with a K or a C?
At the moment, I'm using it with a K, but with very bold inverted commas. Competence, I will describe to your lordships. Again, it won't take long, but when I come to it, that there are variants of this doctrine. There is an original German variant, which is what competence with a K actually was. It's since been repealed in Germany. There is a French conception, compétence de la compétence, which is different. And there is an English conception, which comes from Devlin, probably before Devlin, but recognised by Devlin in the 1952 or 3 case of Christopher Brown. which is different again. But all of these variants have one thing in common, and that is the laws of physics. A tribunal is entitled to inquire into its own jurisdiction, of course.
And New York doesn't say anything about this.
No, it is not legislated for in the New York Convention.
And does it fall to be ignored then in the
No.
New York context?
It's a doctrine which has been recognized in all modern arbitration jurisdictions, and one has to read the New York Convention with it in mind. You cannot construe the New York Convention in such a way as to undercut the doctrine of competence. I use doctrine loosely because there are variants. Because all that it comes down to is a simple, logical proposition, and that is as follows. A tribunal is entitled to inquire into its own jurisdiction, but not finally, unless the parties have specifically agreed by an ad hoc agreement that the tribunal can rule on jurisdiction, finally, i.e. as a merits issue. The tribunal cannot pull itself up by its own bootstraps. It will take a court to finally determine whether the alleged arbitral tribunal is in truth an arbitral tribunal. Now that is a matter of logic. One doesn't need much authority for that. It's a basic proposition. You can have, and in English law we recognise this, not all jurisdictions recognise it, you can have what we have loosely called an ad hoc agreement, where you will allow a tribunal specifically and expressly to treat a jurisdiction issue as a merits issue. So we could contract that this tribunal will determine this issue of jurisdiction finally.
Just like any other issue which could be agreed
Like
between
any
the
other
parties.
issue. But those are rare agreements. And it's not, in the absence of that agreement, all that you agree in international arbitration rules, in any arbitration agreement, implicitly is the tribunal may well, like any other court, investigate its own jurisdiction. But it cannot give itself final authority. If, in truth, there is no arbitration agreement, there is nothing which the tribunal can say to change that, because they're not a tribunal. So that is something which, where this is important in the New York Convention, is the concern on jurisdiction features as an essential procedural safeguard, one of the few limited safeguards that were allowed to stay in Article 5 of the New York Convention.
Where exactly do we find that in 5?
In Article 5, it's
Yes.
5.1a. And that's simply the validity of the arbitration agreement.
I see.
It's nothing more than that. When the predecessor of UNCITRAL met in the 1950s to draft the New York Convention, to get over the problems of the Geneva Convention, they undoubtedly tried their best to come up with a pro-arbitration regime, which improved on the inadequacies of the predecessor, the Geneva Convention. But what they did was they came up with they made it pro-arbitration by limiting the scope of Article 5. But what you get in Article 5 is the irreducible core. Those are the minimum internationally accepted standards. And of course, the first one is an arbitration agreement in 5.1a.
Actually, it's a very good description of the different types, different meanings of competence in China Min Metals.
And citing first options in the Supreme Court.
Absolutely.
First options went through it very well.
Yeah.
And in fact, if I can just quickly, again, give you a sneak preview of my full submission on competence, the variations are really of timing. There are differences between France and England, for example, as to when you can raise the question in court. Does a court have to sit by and wait till the tribunal's finished before the court then decides finally? Those are the kind of variations that exist. In France, it's more restrictive. In America, you can go at any time to court. But the underlying fundamental principle is the same throughout, and that is the tribunal cannot give themselves jurisdiction.
And they say that, interestingly, under the German model, the strictest form, it only exists in a case where the parties have agreed to a competence clause.
Now, that's what I was just explaining. That's what we in England call we've called it an ad hoc.
Yes, exactly, an ad hoc.
And
they say that even then, yeah, you can have judicial review, of course, when the making of the ad hoc agreement is itself
and why
challenged.
Is this, I mean, as lawyers, one charges more by using a foreign term, but competence has grown up as a term of art. What the actual doctrine meant was simply what my Lord Mance has identified, which used to be recognised in Germany. You could have what in Germany was called a competence clause in your contract. And that meant you were expressly endowing a tribunal with the power, unusually, to rule finally on a jurisdiction issue, what we would call an ad hoc agreement. If I mention a case that's not in the record, LG Caltex is a well-known Court of Appeal English case where that was recognised. But that is an old doctrine in Germany. When Germany enacted the Unzertrial model law, they abandoned it. So what we call, I mean, the actual original competence doctrine doesn't apply in Germany anymore, and Germany doesn't recognise these ad hoc agreements.
What you can't in Germany
because
submit that issue to arbitrators.
No,
even entirely separate.
Even entirely separately, they say if it's jurisdiction, then the court has the final say. Full stop. You can't even detract from that. Now that's more extreme.
But what about the jurisdiction of other arbitrators? Could you have an arbitration on the question before arbitrators A, B, and C on the question whether arbitrators D, E, and F have jurisdiction?
That I have no idea, I'm afraid. And it's a question of German
Logically,
law.
it shouldn't make any difference.
It shouldn't make
in
any
England,
difference.
it wouldn't make any difference.
No, in England, we are not concerned by this in England. As long as you have identified your dispute and you have consented to arbitration, you have an arbitration agreement. If you've identified a jurisdiction dispute, so be it. Doesn't make any difference for our analysis. There is sensitivity in some countries about this, and in Germany they have now backtracked.
I mean, I don't agree, actually, that they're not common. To my mind, they're quite common. Because if you have a dispute about jurisdiction, one way of resolving it is to have an ad hoc agreement. Yes. And they are, in fact, quite common.
Well, they do happen. I mean, these are anecdotal when one says common or not common, but yes, of course.
So in Germany, what happens? The proceedings are stayed, are they? And you go to court and argue it out there.
Yes. So Germany follows a modified form of Article 16 of the model law now. They've enacted the model law. And essentially, and there's more detail on this, which we can come to later, essentially in Germany, the court has the final say on all matters of jurisdiction. In America, you can go to court at any stage. France is the most restrictive. You can go to court in France on a jurisdiction issue on limited grounds before the tribunal has commenced, if something is manifest, broadly speaking. Then you cannot go to court until the tribunal's finished. Then you can go to court. And in England, in the 1996 Act, we've got particular provisions which allow you to go to court if you've not taken part in the proceedings, Section 72, or by consent, Section 32. Otherwise, Section 67, you go to court when there is an award. So I don't want to overly confuse things with all the detail, but the thrust of this point on competence is...
Can you take part in proceedings without prejudice? You can you?
Under Section 72, yes. Yeah. If you reserve. But the point about this are simple propositions. Competence, matter of logic. The tribunal can't have the last say. New York Convention, minimum irreducible core of safety measures in Article 5, if I can put it that way. It allows the enforcing court to inquire into whether or not there was a valid arbitration agreement. And there's no basis from that irreducible core to do as Dallah seeks to do, which is to reduce it further. That's the thrust of the submission. There's no basis to reduce it. It's already the minimum. If you then say, well, in fact, there's a different standard of proof or deference or presumptions, what you're doing is you are cutting back on Article 5, when Article 5 is already cut back to the minimum. Arbitration is sometimes described as a secret garden. There may be delights in the garden. You have to find the gateway into it. And the point is that that gateway is carefully monitored. If you break down the walls and start applying arbitration to everybody, it becomes a different thing.
Can I just take up one point, because we wouldn't want to say anything on it which was inappropriate for the future. But you've referred to the American distinction between arguments about the scope of an award and arguments about whether there was an arbitration agreement at all. I mean, I can see that if you've got an arbitration body, one would give particular attention to their view as to whether an issue was within their powers. But as a matter of logic, if an issue arose under Article 5, 1C, as to whether the award dealt with a difference not contemplated by or not falling within the terms of the submission to arbitration, or contains decisions on matters beyond the scope of the submission to arbitration, as a matter of logic, it's difficult to see why the court's approach to that should be any different from its approach to a question whether there's a valid arbitration agreement at all. I mean, the issue is essentially whether there's a valid arbitration agreement covering what was decided, and that should be an issue which a party is entitled to come to court to argue and have decided. If a party hasn't submitted something to arbitration, then it hasn't submitted it.
Yes, my Lord, if I may say with respect, that is absolutely right, and that's why I've tried to analyse this in let me state it again, see if I can make it more clear. Underlying all of this is competence.
Yeah.
Whether it's initial consent or scope.
Yes.
If an arbitral tribunal is in place without uncontroversially for matters A, B, and C, it can't give itself authority for matter D. It's the same point. So the first point for all of this, whether it's initial consent or scope, is competence. Having said that, if you want to then make the test a little bit more nuanced by adding in a presumption, a degree of deference, change the burden of proof, you are not changing competence, you're simply altering the nature of the court's exercise. But it remains for the court to determine the issue.
Well, I think
it's not a big difference.
Yeah, you're going to have to help us on that, because I think Ms. Howbrand's whole argument is that that's just what you can do. You can have a sort of situation where you start 15 love down or up, which way you're looking at it.
My submission is paragraph 233, and that of my written case, and that is, it's the same test as this court applies to section 67 of the Act for domestic cases. It is a question for the court to rule upon ultimately. I am not urging you to apply any deference or presumption. If you want to apply any kind of particular presumption, you can only do so in my submission once you've got beyond the initial question.
Yeah.
But is there any difference between C and D as opposed to the proposition relating to B in section 103, and indeed Article 5? Probably easier to look at the article, actually, if you wouldn't mind.
Of the convention?
Yes, of the convention. I mean, if you've got that readily
yes,
to hand. Just to try to follow up for the point. I mean, I can see the point about the starting point, the absolutely fundamental start, which we get in A. But what about D? The procedure was not in accordance with the agreement of the parties, or not in accordance with the law where the country took place. There you've got you would say, well, you've got an undoubted agreement, and what one's concerned with there is something less fundamental, is the way the agreement is actually being worked out. Is there a difference then in the exercise?
My Lord, the question that I would submit gets asked, one should ask for each of these grounds. There are two questions. One is there a valid arbitration agreement? Secondly, does the alleged arbitral tribunal, whose award one's looking at, actually have status? Now, you have to ask those two questions for each of these grounds. When one gets to a ground such as the procedure was not in accordance with the agreement of the parties, it is possible that the procedure for the appointment of the tribunal was not in accordance with the agreement of the parties. Then you are dealing with an alleged tribunal, not a real tribunal.
Right, I see. So the composition of the tribunal, which is the first few words of there, is fundamental.
Yes, because the court is being asked to give some special reverence to an award of an alleged tribunal. So there are two prior questions. The one is, have you agreed to arbitration? Secondly, that tribunal, was it a real tribunal? And in my submission, one can ask quite simply those two questions for each of these grounds.
And if the answer to those is yes, both those questions is yes,
Yeah.
then remaining questions, even though they may be jurisdictional questions, I mean, if you take my Lord Mance's point, for example, there are lots of disputes go on about what the scope
Yes.
of what the true construction of the contract is. Suppose you I don't know, refer all questions relating to demurrage to an arbitrator. Well, there might be a scope for dispute whether a particular dispute was a claim for demurrage or
Yes.
not. What that sort of issue, where does that fit into the analysis?
If it's jurisdictional, you are bound by competence.
I mean, even though you've got a valid
Even though you've
arbitration
got
agreement,
a tribunal,
and you've got a tribunal with status, so those aren't the only two questions.
sorry?
Those aren't the only two questions.
No, but those are the essential questions.
Yes, but if both those are answered yes, are you into a different part of the analysis, or are you?
Because those two questions are asked with the underlying competence principle
Yeah.
throughout all of this. Some of these grounds don't go to competence. For example, public policy.
Yeah.
Westacre.
I think you're distinguishing between all questions which go to jurisdiction over the issues decided and other questions such as procedure, whether the tribunal has done what was agreed by way of procedure. And so
But it
on.
might be a question of construction of the arbitration clause, mightn't it? Because if you answer questions 1 and 2, it might be possible to say, in relation to the point I put a moment ago, well, the parties intended that questions of that kind should themselves be decided by the arbitration.
Oh, certainly.
By the arbitration.
Certainly.
And they might include what, on analysis, would be questions of jurisdiction.
Like the many cases on what disputes arising out of this agreement.
Yes.
Of course, but those are jurisdictional questions.
Yes.
The scope of the clause, of course.
That was the issue in Occidental and Ecuador, wasn't it? The scope
Yes,
of the
and
arbitration.
interestingly, that case was a good example where, in order to answer it, one had to look at what might be thought to be real merits questions because you were construing a BIT.
Yeah.
But still, it comes to competence in my submission because it's jurisdictional.
And they were actually decided in the courts, weren't they?
Yes.
Subsequently,
Yes.
there was a
Yes, the
detailed judgment holding
They
it was
were
within the
up
jurisdiction.
to the Court of Appeal, and then they went back to be decided. But when it got to the Court of Appeal first time round in Occidental Ecuador, the question was the construction of Article 10 of the US Ecuador BIT, which was about tax measures.
Yes.
And because of the construction of the system of the BIT...
That was the first time I realised you could have a contract governed by public international law.
Yes.
You say these points are competence, but actually they're just competence.
Yeah, exactly. I'm using competence with a K as a technical term, but actually, if this court, if I may say with respect, would do a favour to the international arbitral community, it would be to abandon the term competence with a K, because it's entirely misleading.
But and did just use the word once.
Use it once with a C.
With a C.
Would be much easier.
Well, competence
Not
with a small c.
Not competence.
Not la competence.
And people don't like it because it means laymen can start to understand it. But,
Yes, quite. It has a sort of magic about it.
but this is the confusion. It's actually very, very simple. What we're talking about is a tribunal, and if I may say also, the best description of what the process is, at least through English eyes, is Lord Devlin in the 1950s. And that was set out in, usefully, I've quoted it in my written case, it was set out by the DAC when it was chaired by Lord Steyn in its 1994 report on the infamous Furlonger draft.
Paragraph 214, page 227 in the bundle or starts of your case, yes.
Oh, yes.
226 it starts.
Yes, exactly. So that was the DAC's analysis at the time of the doctrine in English law. I at the moment, I can't now, if I say, recall who wrote this, but it was under the chairmanship of Lord Steyn, and it's a very useful analysis through English eyes of the genesis of the rule in the civil law tradition, and the genesis in England. We can look to competence in France and Germany, but for our own purposes, it is a very simple doctrine in England. And we have to construe the 1996 Act and the New York Convention with the basic premise in mind.
Well, just help me on one point then. All right, in a case like this where we're dealing with documents in the main and are able to analyse them for ourselves, and we've had full argument, that may be one thing, but just take a case where a party appeared in front of the arbitrators to argue an issue which depended to some extent, say, on oral evidence, and the arbitrators heard oral evidence on each side and came to a conclusion, whether it was about whether a signature was forged or whatever, or whether a particular document was enclosed with a letter or whatever, which was essential. Now, you say they came to the wrong conclusion. Can you argue the whole issue all over again with fresh evidence or the same evidence in court?
Yes.
Now, we have to face up to that.
Yes, you have to face up to it. And it's the same exercise as under Section 67. Again,
Presumably the arbitrators could say, don't darken my doors, I'm not going to listen to all this. I'm not having 4 weeks of argument from the government of X under cover of a without prejudice clause, knowing perfectly well that if I decided against the government of X, they'll be entitled to relitigate the whole thing all over again. I could say, well, I'm not hearing that. Could I, as an arbitrator?
The tribunal will do what it wants, and if it's a modern-style continental tribunal, it will give you 3 days for what might take 6 weeks in an English court. That's what they want to do, but that's not the question. The question is the English court.
No, but although the arbitrators have power to determine their own jurisdiction.
But not finally.
But not finally.
Not finally.
And they don't have to hear any argument about it. They can just simply say,
do what they want.
We either do or don't.
They do what they want, consistent with their procedures and the lex arbitri. But when it comes to an enforcing court, your mandate as a recognising and enforcing court is the same mandate as under Section 67 for a domestic case. It's a simple inquiry. Was there or was there not jurisdiction? In order to...
In Section 32(1 of the Act is completely open-ended, really, the way it's expressed, isn't it? I mean, the court may determine any question as to the substantive jurisdiction of the tribunal.
So, Section 32...
32?
32 is a separate mechanism in the 96 Act, distinct. Section 32 is a special provision for parties to agree on jurisdiction as a preliminary point of law and refer it to court. It's the equivalent of Section 45 of the Act. It was a special selling point put into the 1996 Act in order to short-circuit the jurisdiction issue. So it's not. Sorry, I haven't made that very clear. There is a provision in Section 45 of the Act to refer a preliminary point of law to court by consent. Section 32 does the same for jurisdiction issues. And this is explained in the DAC report. It was felt at the time that the 1996 Act was drafted that there are times where it would be very helpful for the parties to actually have the competence process finished at the beginning to know whether or not there is jurisdiction. Otherwise, you may invest a lot of time and money in an arbitration, and then the whole thing gets unwound at the end of the day under Section 67.
And that's what Section 31 is all about?
31 sets out how objections to jurisdiction are to be handled by the tribunal.
The ex post facto challenge is Section 67.
Yes.
Yeah. Right.
So it's only 67 that we're concerned with.
Yes, right.
32 is a separate process. Now, under Section 67, the points that my Lord Mance has mentioned are the same, came up from Azov shipping onwards. As your Lordships will be aware, there is a bulk of authority now on Section 67 where this question was raised. The court said, should the English court really be hearing witnesses again that have testified already in front of a tribunal? Should they have 3 days, maybe 5 weeks, whatever it takes, trying issues of jurisdiction? And the answer was given very clearly in my submission by Mr. Justice Ricks, as he then was in Azov Shipping. That was then taken up by all subsequent commercial court cases and Court of Appeal. They're listed in my written case. Peterson Farms, there are many, many of them. And what Mr. Justice Ricks said was, why should the English court be put in an inferior position to a tribunal? If a tribunal has access to witnesses, why should an English court be put in some secondary position where it can't hear the evidence itself? Even though it may be cumbersome, we are dealing with the essential initial step. Was there consent or not? And if you have to have a trial to determine that, well, so be it. It's that important. And in this case, my lords, This is a prime example, as I will endeavour to show you with your permission, on the facts, where you've got a tribunal that did not have the advantage of having counsel for Pakistan argue in front of it. It had argument put to it on a completely different basis, a factual record that was not gone through in the same detail as it was in front of Mr. Justice Aikens and the Court of Appeal. It's a prime example of why you've got to have a de novo hearing. The government of Pakistan, I think it accepted, had no obligation to turn up in front of this Paris tribunal. It had every right to stand back and wait to see where recognition and enforcement might be sought. Nothing happened in France. An application was made in England. So Pakistan came along to England and put its case. Why at that point should it not be able to put its case fully, even if that required a 3-day hearing in front of Mr. Justice Aikens? And I promise I will do this very briefly, but when you tiptoe through the factual record, you can pick up points that obviously were not put to the tribunal that are compelling on this issue of consent. So the analysis under the New York Convention must be, we are talking about the minimum safeguard.
These points in argument or in evidence? You say you can pick up points as you go through it, through the argument?
On the evidence.
On the evidence.
On the evidential record. You can pick up documents that were not considered at all by the tribunal, apparently, according to their award. Pakistan has focused on those documents when it participated in front of Aikens. Why shouldn't it be entitled to do that? But that requires a full hearing. So, Lord, I will come to these in order, these points that we've...
I mean, it seems to me you've covered competence, haven't you, rather fully?
Well, there may be some other points of detail, because I was originally in my executive summary, although I left it a little while back. Lord, can I just finish off the summary with the following points, and then I'm going to come to the points in a better order.
Yes.
For the sake of your notes, if I may say. The factual record does need to be looked at, but I will do so very briefly. But the characteristic feature of this case, which was found by Mr. Justice Aikens and by the Court of Appeal, was that this is a case not just where the government of Pakistan never consented to arbitration. Unlike the Svenska case, but similar to the Pyramids case in France, in this case, the government made positive steps not to be bound. It interposed a trust with separate legal personality. It's very difficult in those circumstances to divine a common intention, subjective intention, for it to be bound. And that can be shown, and I'll do so very briefly, by looking at the facts. And I'll just highlight...
In all cases, the moral of the story is if you want to contract with the government and bind them to an arbitration, then you just put it in the contract. Make them sign it. And,
Dallah is a grown-up entity with sophisticated lawyers. It is a major international concern, a group of companies. It had already contracted with the government in the MOU. And the one document you were not shown, but I will show you, were the instructions after the MOU, after the trust was set up, the instructions sent by Dallah to its Pakistan lawyers on drafting the contract. We've got those. And that instruction says the current shape of the project now is it's going to be with the trust. So that's there.
I thought we had seen those summarised in the case.
Yeah.
It's the one which refers to the government guarantee.
Yes.
Yes, there's 4 paragraphs.
Yes.
Yes.
So we've got the best evidence of what Dallah was intending.
So you find the reservation of immunity in the MOU, but not in the agreement. I mean, that's just another example of it, is it? That
Yes.
Where the government was a party to an agreement, it put in the reservation.
It put in the reservation of
Yes.
sovereign immunity. It decided, as many governments do, on non-institutional arbitration. Didn't want the ICC, ad hoc arbitration in Saudi Arabia. They had political reasons for that. They had, it was in the name of the President of the Islamic Republic of Pakistan, compliant with the Pakistan Constitution. That's how, if you want to bind the state, that's what you do. That's why the President of Pakistan appears so frequently in our law reports. All that was done carefully. When it came to the agreement itself, all that was changed. Dallah had sophisticated lawyers. They knew what they were doing. Why didn't they simply attach a sovereign guarantee? Why didn't they simply, like in Svenska, get the government to put in a rubric on the signature page? There are many mechanisms that could have been done. Now, the reason for stressing this at the executive summary stage is simply to say this shows why the court's got to have a de novo hearing. Because these go fundamentally to the first building block, which is consent. You can't allow a tribunal to go off on its own exercise, disregard this evidence, and then say, well, the court is now constrained by what the tribunal did to some high-level form of review, because then you lose the safeguard.
Well, can we move beyond the executive summary?
We'll do that now. Can I address the first ground, that is the level of review, in the following way? Firstly, to make the points that I want to make very briefly on the facts. The reason for doing that is to show your lordships again the need for the de novo review.
Now, as far as the facts are concerned, you covered them very fully in the written case. Can we use the case as the basis for it to save time?
One can, although in fact it will be as quick to take volume C and simply look at the documents. There are only about 3 or 4 documents to show you.
Volume C.
3 documents, right?
Which volume?
It may be reducing. Volume C.
C.
Expression 3 or 4
I know,
documents.
it was dangerous. It was my fault. I should have said
Expression 3 or
4
4
or 5.
documents threatens, or appears to threaten, half the volume. However, it would help me at least if I were going to make a note about it to see where in
Yes.
your case
Yes.
you
Well,
referred
I
to.
mean, the facts, as you would have seen, have been dealt with both exhaustively and exhaustingly in my written case
Right.
from page 23. Up to...
Sorry, when you say page 23, do you mean your paging or
Yes.
the paging in the core bundle?
No, sorry, my internal page of my written case. My internal page 23 up to 44. Yeah, is where I deal with the facts in my written case.
Yes.
The facts break down into 3 clear phases. Firstly, initial dealings between Dallah and the government leading up to the MOU. Common ground, the government was bound by the MOU. Then secondly, the change in structure that happened after the MOU. That's the significant point in this case. And then thirdly, and the second stage goes up to the agreement. And then thirdly, post-agreement conduct, which of course Malone and Friend relies upon. That's the point in the chronology now that she focuses on. The first stage, initial dealings. The Dallah throughout this exercise was represented by Orr Dignam, which is a leading law firm in Pakistan. They are the ones who drafted the agreements. If one looks at bundle C, page 5, you will see the first draft that gets produced by Orr Dignam and co. Page 5. It's a letter dated 22nd of June 95, a fax, and it has attached to it a draft of a proposed agreement which is put by Dallah to the government. If you turn over, you will see the draft dated 21st of June 1995. Under it, on the top right, Orr, Dignam and co. They're the lawyers. This is interesting if one compares it to the actual agreement at the end of the day, which is at page 191 of volume C. If you compare the two, you will see the change that happened. Orr Dignam have drafted both contracts. The proposed one is between the government of the Islamic Republic of Pakistan and Dallah, and if you turn through the pages, it refers to the GOP as the obligor all the way through. When you get to page 191, that has been changed, but the structure of the contract is similar. What happened next was that the trust was set up. Why was it set up? Why did the trust get interposed? It was because it was supposed to be a self-financing, Sharia-compliant entity. And the point was that the funds that would be collected for the Hajj pilgrimage would not be tainted by interest or what's called riba, R-I-B-A. The idea of it was that the trust would collect money from philanthropists and from subscriptions, and all the money would be Sharia compliant, clean and untainted, which is important in terms of the performance of the Hajj. Page 28 of the bundle, one gets the indication from the government of the decision to set up the trust, July 1995. I'm not going to read it, but that sets out the intended financing of it, to be self-financing.
120, did you say?
28.
Oh, sorry, 28.
That's document 2.
I was worried that my Lord Clerk would be counting the document.
Well, all this is referred to in detail in your,
It is.
in your case.
With your indulgence, if I just tiptoe very quickly, I'm not reading the documents, just to show how this... I'll stop the minute I'm told to stop.
Does it go to the issues on which we specifically asked for assistance?
Well, my Lord, it may go, if I apply a liberal reading, to the level of review. It goes to the point about the need for the court to actually look at all the documents itself rather than through the prism of the tribunal's analysis. I'll expedite at this point further. MOU comes page 30. The points that were not analysed by the tribunal but were analysed in detail before Mr. Justice Aikins were, for example, the naming of the parties in the MOU. As I mentioned before, Article 173 of the Pakistan Constitution. You'll see that the MOU is in the name of the President of the Islamic Republic of Pakistan. Now, I'm going to go over all the points you've already got on that. Let me move in the chronology to the second phase, which is then the change in structure. The trust gets established after the MOU. So the MOU is concluded before the trust is in existence. The ordinance you have seen, which is at page 93. The trust in paragraph 3 of the ordinance is to have separate corporate personality. I mentioned just in passing, my old friend was asked the question, how long was the trust to be in existence? She said we thought it was perpetual because it said perpetual succession, but of course perpetual succession is a term of art. It just tells you that the company survives even if its ownership changes. In any event, it's set up at that point. Now, from that point onwards, people are acting with dual capacities, but there is no new letterhead. The change in structure that then happens is from February 96 onwards, and the key letter, which you were not shown, is at page 113 of the bundle. This is a fax message from Dallah to its lawyers, or Dignam, from Shezi Naqvi, and it's dated the 3rd of April 1996. Begins, further to our discussions with the GOP, the current shape of the transaction is as follows. Number 1, Dallah Real Estate and Tourism Holding Company, Dallah, will enter into an agreement with the Awami Hajj Trust for the following. No mention of the GOP to be bound as well. This is the moment where we get Dallah's subjective intention. And phase 1 is outlined with the trust as the obligor party. The trust to pay a down payment, Dallah to enter into leases with the trust, and so goes on throughout this letter. Now the question is, well, firstly, of course, this is the moment where the GOP could have been bound. If Dallah were sensible at this point, having already concluded the MOU, they would have said to Dignam, get a guarantee as well, or bind them in. The question for your purposes, under the French test that the other side rely upon, is if this is the intention at this point, why does it change? There's got to be a confluence of intentions, common intentions. Dallah at this point is intending the trust to be the party. Why does that change later? We've got no evidence of that at all, that somehow Dallah later thinks, no, I think it should be the GOP.
Can I just understand who the various parties are? The Trading UK Limited represents whom?
Dallah.
So this
And
is
you can see-
Dallah's fax message.
I'm sorry.
Okay, this is Dallah's proposals.
Yes, this is from Mr. Shezi Naqvi, who is Dallah's representative. He's the one who signed the witness statement that Reliance is placed upon. He's operating through Samaha Trading, but he is Dallah. He's writing to his Dallah's lawyers in Pakistan, in Islamabad, Messrs. Orr, Dignam and Company. And this is the instruction for Orr Dignam to draft the contract, which they then do. Lord, before the agreement was concluded, the trust already, the ordinance had to be repromulgated because it lapses every 4 months. It was next repromulgated, if you go to page 172, on the 12th of August, 1996. This is before the agreement was concluded. So Dallah knows, if they didn't know already, that this trust's life is dependent upon repromulgation of an ordinance. It's already happened.
Well, they say they were relying on the government to do the decent thing and do that.
That may be so.
Underlying basis of the whole deal, they say.
That may be so. But this is a party that has already concluded an MOU with the government and gone through all the formalities needed for that.
For some reason, they don't seem to have proceeded under the MOU.
172.
Well, because they have a difficulty. They want to say that the MOU continues and therefore is some framework agreement because it's the only contract to which the government is bound. But they've never commenced an arbitration under it. So
Well, I see that.
there we are. That's the problem. So page 172. Now, the lapsing of the ordinance happens by effluxion of time.
Is there any evidence that Dallah actually got notice of this, though? I mean, frankly, it's not the sort of thing that would occur to someone normally. That Section 89 of the Constitution abolished a trust brought into existence for a particular purpose after 4 months.
My Lord, with respect, this is very, very well known in Pakistan. The reason is...
Well, that's giving evidence.
No, I'm going to restrain myself from giving evidence. But the short answer is I am not aware of any evidence that Dallah saw this.
No, I mean, it's part of your case later that people were acting unaware of the failure to repromulgate, and I just wonder actually whether people are aware at all of the need for repromulgation.
Well, Orr Dignam must have been. Orr Dignam.
Well, that's the point. The point I'm aiming at. Orr Dignam must have done their due diligence.
Yes, I see.
If they are instructed to contract with the trust, to draft a contract with the trust, they must have worked out what the trust's life was.
What was the reference to your... Keen as I am to look at the documents, I'd like to know what the reference to the 12th of August.
172.
172, thank you.
I'm sensitive about using up my quota.
Yeah.
What happened next, where the agreement came in draft from Orr Dignam, and it passed through the government, 2 departments of the government, before it was concluded.
And does this agreement have the guarantee, the government guarantees it?
It has it as a separate, yes, the government, under Article 2 of the agreement, which the final agreement is 190, page 190, 191.
Yeah.
It's got 3 references, or 3 or 4 references to the government. 2 of them are this guarantee provision in Article 2.
Sorry, what are we looking at now?
I've gone to the agreement.
You've gone to
My
the
Lord
agreement.
Clark
So we're
asked
looking
me.
at page 191.
Yes.
And was where I was too, actually, because the second line does refer to the ordinance.
Yes.
So a draftsman, any lawyer
Draftsman
drafting it would
knew
put
the
it in.
ordinance, must have checked the ordinance, and that's a telling point. Why identify it with such specificity? It's by reference to that ordinance.
And who drafted this?
Orr Dignam, Dallah's lawyers.
And had the guarantee, the clause 2 guarantee, had that been in each of the previous drafts? Well, since the trust came on the scene.
The previous drafts of this agreement, yes.
Actually, it is quite interesting, that reference to the ordinance,
for all that auditing them are supposed to be experts,
Yeah.
they got the wrong one.
They've got the original one.
They got the original one, so they're not conscious of the
No,
amendment.
and the point is that the ordinances come and go by a fraction of time, but I'm faced with an argument about good faith and about what should have been known, what was known. So, I mean, on both sides, there's a question of, if one's talking about balancing the merits, it's a question of, well, perhaps Dallah ought to have known as well. Certainly, they are a grown-up commercial entity that should have done its proper due diligence. And on any view, at this point, they are intending to contract with the trust.
Does subjective attention, I see, subjective attention takes account of what objectively you ought to know, does it?
No, I mean, and the long grass of the French test awaits us if I'm allowed anywhere near it. But the French legal test...
Very few cases are decided in the long grass.
I'm aware. I'm painfully conscious of that. The French test is a subjective test, but that may be to be parked for a moment.
The agreement, of course, may have been drafted sometime before it was signed, and one has to...
But we do know it passed through the hands of the government ministries who were looking at it.
Yes.
And if they had intended to be bound, they would have picked up the point that, for example, they're not named. It went through the Ministry of Law. We've got documents on that here. I don't want to give the reference because I've only got one life left, I think, on documents. But it went through the Ministry of Finance. It went through the Ministry of Law. They have not made any observation, for example, that Pakistan is not mentioned. It doesn't name the President of Pakistan, consistent with Article 173 of the Constitution. So we know their intention seems to be, one can deduce, seems to be clear from the documents, as was Dallah's. And of course, the points on the agreement you already have. The agreement is drafted in terms of the trust being the obligor.
But all this is quite plain. I mean, it's perfectly obvious looking at the agreement, just looking at the agreement.
Right. Can I just make
There's no hint that the government, and
More
I
than
think
that.
Ms. Hardron recognises that.
They even changed the standard ICC arbitration clause. If you look at clause 23, which is the agreement upon which Dallah now relies, the standard model arbitration clause for the ICC, which is in your papers, in the authorities bundle, reads, all disputes arising out of or in connection with the present contract shall be finally settled.
And what's the cross-reference there?
The reference is Authorities Bundle 1, Tab 10, the ICC rules. And that's got the model ICC clause in it. They changed that in this contract, and they've written instead, any dispute or difference of any kind whatsoever between the trust and Dallah. That's page 199 of Volume C, Clause 23 of the agreement.
Yes, I see.
So if they had chosen the model ICC clause, it might have been broader in terms of parties.
Well, we've reached 4 o'clock. I don't know whether there's anything quickly you want to first refer to before we close.
Can I just ask one quick question? On page 177, going back to these ordinances, I see that the second ordinance refers to the repeal of yet another Awami trust, which we don't have.
I believe that's not in the papers. This is the second repromulgation.
So this is the second repromulgation.
Yes.
So because otherwise you've got a gap in terms of time after 4 months.
Yes.
I see.
Yes, well, that makes the reference in the agreement a little odder. If it's the first one.
Even more inaccurate as possible.
Well, shall we leave it there just now? I hope you won't have too much on the facts.
No, overnight I will decide on my last reference and then move on.
10:30 tomorrow morning.